Well, good morning, the lovely Frank and Liz, and welcome, Chris, to our little chat that we have sometimes to help to demystify different aspects of information governance. And today we have got two key topics. The first one is going to be about DUAA, the Data Use and Access Act. And I guess what many people really want to know, what exactly are the main challenges of that legislation?
Thanks, Heather. Thanks, Frank and Liz, for having me. Really excited to be here for the first time.
Nice to see you.
Yes, indeed.
Yeah, I think the main challenges are around interpreting what it actually means for our businesses, because there's a lot of material in there, and I think one of the challenges that businesses have been really grappling with is how do I use this? How do I implement it? So one of the most talked about provisions is the changes to the search obligations for controllers responding to access requests. And I think a lot of organisations were initially quite excited to hear that there were new grounds on which they could potentially decline access requests that are unreasonable or disproportionate. So the DUAA puts on a statutory footing for the first time this principle of a reasonable and proportionate search when responding to an access request, and that ability to insist on that reasonableness and proportionality is actually backdated to the 1st of January 2024. So that can be potentially very helpful. So this concept has been around for quite a few years, but this is the first time that it's actually appeared in legislation. So how helpful is it, and what can organisations do to actually make use of this? Well, rather unhelpfully, the Act itself doesn't define what's meant by reasonable and proportionate. That will presumably fall to the ICO, and they've started publishing guidance on this. So we do have some insights on what's meant by that. There is a piece of case law called Ashley against HMRC, which established that when you're determining the scope of a search, you can consider the time required for thorough redaction and give what it calls weight to the pain caused by the request beyond simply the time taken to conduct the initial search. So you can take into account the entire process, all the labour that has to go into it when thinking about what's reasonable and proportionate. But the case law tells us that bar of proportionality is very high. The court said that you can't walk away from your obligations just because it's difficult. And they also talked about poor file management and poor information and records management governance not being an excuse for declining it. So I think the sort of short answer is that we can potentially use this to decline certain really unreasonable access requests, and it's a positive development for data controllers. But if you want to take advantage of it, you're going to need strong records management, good technology, and a decision that's been thoroughly documented, probably with professional external legal advice. The other thing to bear in mind about this is that what's considered reasonable is likely to shift over the years as tools become more effective, which will sort of narrow the field into specific areas or date ranges and make activities that were once unreasonable reasonable, because they'll become easier. So I think that's one of the key challenges is working out how we can really take advantage of some of these provisions. There's also the automated decision-making provision. So there's a shift from a prohibition on automated decision-making to permitted automated decision-making subject to certain safeguards. There's recognised legitimate interests, which has caused a lot of discussion and interest. So there's new lawful grounds for processing data for crime prevention, public security and defence, emergencies. It doesn't remove the need for establishing a legitimate interest, but it does remove the need for a balancing test. So for organisations, mostly in the public sector, that can rely on that, that's going to be very useful, but the challenge will be operationalising it.
Sure. Liz, Frank, have you got anything to add to that Chris has said, or things that people should particularly focus on?
I do think the legitimate interest area is one worth thinking about and preparing for, because something that I've talked about with a number of my clients is this introduction of it being a legitimate interest if you are passing information to another organisation so that they can deliver their public task. And there is a general expectation that this is going to help or facilitate information sharing. And I think, I'm sure it certainly can, but of course it doesn't stop us all still needing to comply with the legislation. So it's just being really clear what we need to do to prepare for that and actually make use of that clause, because as we know with lots of other aspects of data protection law, just because it's there doesn't mean that people are going to use it necessarily. So yeah, I think that's definitely something that I've already started discussions on with a number of people, but something that and of course it's not just going to be the public sector, because the organisations being asked to provide information may well not be public sector organisations, or may not have a public task, I should probably say more accurately.
Right.
Yeah, and I think this is a really pernickety point, but I thought it was quite interesting that it's not that suddenly there are new legitimate interests, it's that this is a whole new lawful basis. So it's actually a change to Article 6. So that we need to be careful how we document this as well. And it might mean revisiting privacy notices, revisiting records of processing activity to make sure we accurately reflect the revised lawful basis in these situations. So that was quite a geeky point. But Chris's point as well about the proportionate search and subject access, as Chris says, essentially that's been the ICO's guidance and that's been the direction of case law for the last few years anyway. But I think it is an opportunity to maybe revisit our DSAR processes, possibly revisit how we describe the right of access. So a lot of organisations, particularly if they get high volumes of subject access requests, they may have pages on their website or guidance they give out to applicants that kind of manage expectations a wee bit. So there's maybe an opportunity to revisit the word in there, be clear with applicants, we are not obliged to search every system in the organisation on the off chance that some of your personal data is there. And I don't know what you guys think about this. One of the things I often suggest to the organisations I'm doing training with or working in SARS with is actually document what your typical approach to a SAR is. What do you think is a reasonable and proportionate search? What are the systems you would search typically for a DSAR from that type of data subject? So if a customer puts in a subject access request, we would typically search this system, that system, that system. And it has to be case by case. We have to have a degree of flexibility. For example, you might say, right, we believe a reasonable proportionate search for a customer is we'll search the CRM, we'll search the main database, correspondence database. But if a customer puts in a subject access request and says, well, actually, I want the audio recording of my call to your help desk on that, well, yeah, we need to accommodate that. We have to take it case by case. But I think there is an opportunity there maybe just to revisit our DSAR processes, document that a little bit more robustly.
Sure.
I think Chris's point is really important around the records management and the governance that has come up in case law before, because I think at the moment this is one of the reasons that a lot of people we work with struggle to use this issue of it being a large volume, is because actually it's a large volume because people haven't managed their records properly. And of course there's a real balance to be struck there to really recognise that needs to be addressed by the organisation, and that's not going to happen overnight. That's something that they need to factor into any kind of data and records management strategies and general information governance. And then, as you say, Frank, they could easily prioritise that by looking at actually where is the majority of their personal data, where do they get requests, and combine that with the opportunities that the new legislation brings, I think.
Yeah, absolutely.
Yeah, it's a really good point. I think it emphasises the importance of getting the governance right, getting records management right, and the fact that the law and the regulator is increasingly looking behind the reasons for the difficulties that organisations have in obtaining data. And if when they look behind those difficulties, the reason is actually that the organisation's not doing what they're supposed to be doing and haven't got their records in order, then there's not going to be much sympathy for that.
Yeah, it's such a fundamental foundation. Getting those things right, not only obviously supports compliance and not getting the wrong side of the ICO, but just generally doing what you do better. So when exactly what's exactly the commencement timescales for the Act?
Can I jump in another point there as well,
Yes.
Heather? Sorry, it's just what I think. I know this is going to sound kind of pathetic, but I'm quite excited about the statutory recognition of complaints processes, which sounds like a tiny little thing, but I think this is a real opportunity for organisations. So to some extent, again, it's reflecting how the ICO has already been working, in that when data subjects come to them with an issue, typically they will say, well, have you talked to the organisation? Have you complained to them? Have you given them a chance to set it right? But there was no statutory provision for that. So under UK GDPR, the statutory right to complain was to complain to the ICO. There was no mechanism for complaining to the controller. But now DUAA introduces this provision that if the controller, so it's not mandatory, but if the controller has a complaints mechanism, then the ICO will respect that. They will say the complainant, the data subject, has to have gone through your complaints process before the ICO will pick it up. So for those of you in public authorities, it's maybe analogous to the internal review process in FOI. So it might sound like a wee thing, but I think this is a really useful opportunity for us to have a formal mechanism of complaints, of revisiting subject access requests, but other aspects of data protection as well. And it means essentially we've got a second bite at the cherry potentially before these issues go to the ICO. It means, for instance, with subject access requests, we can be very clear. Okay, we think we've made a reasonable attempt to deal with your SAR, but if you think we've missed something important, if we've misinterpreted your request, if there's other things, other areas of the business you've been in touch with and we didn't know about, we've got that complaints mechanism. So I think that's a really interesting opportunity, and one of those things that colleagues should, if they haven't already, set up a formal data protection complaints mechanism, document your process, and make sure it's there in any of your SAR responses, any other communications with data subjects.
I do actually think that people do not need to start planning for that, particularly in the public sector, because one issue that's come up already with a number of people I'm working with is how do they distinguish what is a data protection complaint from other complaints, and how do they then remove that from the ombudsman process, which of course is already in place by statute in a number of public authorities. And I think it's not going to be hugely complex, but it does need thinking about, because of course the sorts of people that are going to be exercising this right are already going to be unhappy. So the last thing that people want to be doing is referring them inadvertently to the wrong regulator, or either way. So definitely something worth looking at within your organisation to make sure those processes are clear and people are trained and recognise what is a data protection complaint, and you've got that clearly defined.
Yeah, and it's that key thing generally where something has changed in one area, don't be so narrow focused in that. Where else is it going to impact further around the organisation? So, Chris, I think you were going to add something there.
Well, yeah, I was just going to say, yeah, I think that's a really important point, and adds to the list of practical steps that organisations can take to make sure that they are responding the right way to the DUA, and that's maybe that's a list that we can provide alongside this talk.
Sure.
Just a sort of to-do list for organisations who are affected by it. The only other thing before we talk about dates, the only other thing I was going to flag that's quite interesting about the DUA is the reforms to the ICO. So as well as the complaints mechanism, there's also this new governance structure. So the existing corporate structure of the ICO is being replaced by the Information Commission, which will be led by a chair and board members, which brings it into line structurally with other UK regulators. Now, one of the powers of this new body is to issue interview notices that can compel people, including current or former employees of an organisation, to come along and be interviewed at a time or a place. And failure to appear for that conversation could lead to prosecution. There's also something that I'm particularly interested in as a lawyer, which is the power to require document disclosure. So the DUAA says that the new commission will have the power to issue notices which require certain documents to be handed over. And now, as a lawyer in a law firm, a lot of the material that I exchange with my clients is legally privileged, and that's something that client organisations find really useful sometimes, is the ability to cloak in privilege really sensitive documents. But unusually, legal privilege doesn't apply over the documents that are being requested in relation to this disclosure right. And then there's also an extended time for final penalty notices. So the Act amends the time limit for the ICO to issue a final penalty notice after a notice of intent. So it now has 6 months, but it will be able to take longer for complex cases, which I think will make them feel more empowered to make strong, robust decisions, because they'll have more time to think about them.
Mm-hmm. I do think the provisions around the interview, and I guess in some ways perhaps that won't make too much of a difference, but I am wondering whether that will kind of reinforce roles like the data protection officer, because if notice is going to be issued, where organisations have one, obviously, they would seem to be in the firing line for a lot of investigations potentially. And will that have any effect downline? And of course, I've got an interest in this area, and maybe it won't, because obviously the ICO will already be talking to them, I'm sure, in lots of their investigations. But just that it puts it on a much more formal footing, doesn't it? I think that's the difference.
Cool. So, what's the commencement timescales for the Act?
Well, as we talked about, the reasonable and proportionate search provisions have retrospective effects, so they apply from the 1st of January 2024, and from last September, the legal privilege exemption for data subject rights applied. Some of the digital verification services provisions became active just at the end of last year. This year sees the main data protection changes, including automated decision-making, recognised legitimate interest, and children's privacy provisions become active. In the first half of this year, we would expect the Information Commission Board appointments to be announced, and for that new Information Commission structure to go live. In the middle of the year, we're expecting the complaints handling processes to be implemented. And then we're also awaiting final guidance on complaints, codes of conduct, and data sharing for anti-fraud purposes, and legitimate interest and recognised legitimate interest, which is, as you rightly say, Frank, is a separate new legal basis. So throughout this year, we're expecting more detailed guidance on those provisions to be handed down, and I would expect that the regulator will be taking a fairly softly hands-off approach on enforcement of those provisions until we've got that detailed guidance.
Yep, sure. And I guess maybe what will also be useful, as well as producing a bit of a checklist for people, is a little summary of what those different dates within the commencement periods are, because on the face of it, it's a wee bit complicated unless you see them right in front of you. Well, brilliant. Are we ready to move on to the next bit of excitement that's coming out in the landscape? And that is the European Commission, who have unveiled their digital omnibus package, which was the 19th of November last year. And this is a proposal for regulation on simplifying existing digital legislation. But actually, what exactly is it?
Yeah, good question. It's caused a massive amount of noise in Europe and beyond. It's a series of proposals which are very radical and very wide-ranging, and it's called the Omnibus package because these proposals are comprehensive and very broad, and they reach across the GDPR, the e-privacy directive that we've been waiting to be updated for many years, the EU Data Act, the NIS2 directive, and there's also a separate proposal that relates to the EU AI Act. And overall, the purpose of these proposed amendments is to reduce the administrative burden, clarify how the rules interact with each other, strengthen interaction, and enable safe innovation. That's the idea behind it. And their view, the Commission's view, is that the AI Act and some of these other digital and data regulations are too complicated. They are too fragmented. There's concerns that the complexity of implementing these regulations and particularly of implementing them simultaneously when they don't always marry up with each other is hampering innovation and hampering sort of commercial progress across the EU. So the idea is to simplify everything and bring them more into line with each other and make them more practical. So it's a very noble idea, but whether this is actually the solution is being hotly debated.
Sure. And presumably it's now because so many of these things keep on coming in and people are standing back, they're being impacted, not in a positive way, which is what it's supposed to be about, and not in a joined up kind of a way. Any other thoughts around interpreting what it actually is, Frank or Liz?
Well, to be honest, I think my approach is we'll wait and see what finally comes out, because I think there's still a lot of pushback, a lot of debate to be had in EU. But then, of course, it wouldn't impinge directly on UK law. Clearly, if you're a business who's doing a lot of business with, you've got clients in the EU and what have you, you would have to have direct cognizance of it. If you don't, then you're waiting to see what impact it has on UK legislation. So you're already at a bit of a remove. But just in general terms, I think it is interesting, and because post Brexit, a lot of people were quite concerned that, is there a danger that the UK goes further than the EU in liberalising and simplifying data protection law? Whereas on the face of it, the Omnibus potentially shows the EU going further than the UK has in trying to simplify and roll back a little bit potentially from the provisions of the GDPR. So you could end up in a situation where actually, the EU has a slightly more liberal data protection framework. I don't know if that'll be the case, but there is that potential. Then do you end up with a race to the bottom? Well, will UK, if Europe goes down this route, will the UK re-legislate on data protection to fall in line and to further simplify? But anyway, as I say, that was a very long way of saying I'm going to wait and see.
Well, that's a really interesting point, Frank, because you're right. It does seem to, and this is one of the things that I think has been most controversial in Europe, is that they do seem to have leapfrogged the UK in sort of pivoting towards business-friendly liberalisation of some of these regulations, and pro-innovation is the phrase that's often used, and that really does reverse the dynamic that's been there for a few years, where when Rishi Sunak, for example, launched the UK's approach to AI, there was this idea of the UK being a digital leader, and that was connected with Brexit. It was connected with the idea of we are throwing off the shackles of EU red tape and taking the handcuffs off business to enable us to move forward with these technologies, and that balance seems to be shifting now. Just to quickly mention a couple of the specific changes that are proposed by the Omnibus, just to give people an idea of how radical this is. So that some of the proposed changes include a change to the definition of personal data. So information that can't be used by an organisation to identify an individual using reasonable means will not be considered personal data for that organisation, even if a subsequent recipient could identify the individual. So it's narrowing the definition of personal data, so that if you can't make that connection as an organisation with data that's available to you, then it will no longer be considered personal data. Now that has quite significant implications for the scope of the protections over people's data that I think a lot of people would be concerned about if they understood how that could sort of flow down technologically. There's also a delay to the EU AI Act's rules on high-risk AI. So they were supposed to take effect this August, but they'll be postponed for 16 months. And the rationale for that is that the Commission feels that there isn't yet sufficient support for organisations to actually comply. So they don't want to leave them in the lurch of having these very onerous restrictions on high-risk AI systems and insufficient guidance on how to comply. And then there's a liberalisation of data breach reporting requirements. So the deadline would be extended from 72 to 96 hours, and only high-risk data breaches would be reportable to regulators. So that's a massive change to the data breach notification regime. Probably one that, if it were to ultimately flow down to the UK, I imagine the ICO would be quite happy about, because they're constantly just flooded with overwhelmed with these often quite trivial data breach notifications. There would be a new ground for refusing access requests, which would be a request made for purposes other than protecting the requester's personal data. So that would be massive as well, because that would, from a UK perspective, it would overturn the long-standing principle of purpose-blind access requests. So if any of this was actually to happen, it would really be quite seismic in Europe, and it would be really interesting to see how some of that would flow down to the UK. But as Frank, sorry, go ahead, Heather.
No, I was just agreeing with you. Carry on, Chris.
But yeah, as you said, Frank, I think wait and see is the most is the best advice for UK businesses. As you say, the UK is not bound by any of this regulation or legislation directly. The government's also developing its own AI regulation framework over the next couple of years, which may cause further divergence from the EU position. Of course, UK businesses that sell AI products or systems in Europe will to some extent have to comply with the AI Act. But yeah, while all this is quite academically and theoretically interesting, I think the Omnibus is so controversial and is being so heavily challenged that it's unlikely to be adopted by this August deadline. So for a number of reasons, I think it's much too early to take any significant action on this.
So basically, rather than keeping a watching brief and listening to expert talk about it, like yourselves, there's not really anything that people need to be rushing out and doing just now.
I think that's right.
Yeah. I mean, I think in principle, I completely agree. But I do think in principle, I would hope the UK are having a really good look at this, because if there was one thing, I think I'm probably not alone in saying that we wish the government had done with the latest act, is to consolidate all of our data protection law, because it's an absolute minefield in terms of, particularly when you've got practitioners that are trying to come in and look, and we've got so many things to cross-reference and legislation upon legislation, you know, all of which you have to understand how it fits together and where you need to look for what. And there was a massive opportunity there, I think, to really kind of consolidate all of that. I do think it would have been interesting if this had even been mooted prior to the UK passing DUAA. I think we'd be looking at a very different piece of legislation now, but we weren't, so we're not. And one of the biggest things that concerns me actually is that personal data, because and of course it was some time ago now, and I haven't looked at it recently, but that whole reasonableness of being able to determine or identify people from the data was in the DPDI or something very similar to it, which I fundamentally disagree with, actually, because of that use of that word reasonable. It's, you know, I think it's
a lot of wiggle room there.
Absolutely, and it will take years of case law potentially to sort that out. So, yeah, as you say, nothing to worry about at the moment, but interesting to see where it goes.
And I must confess, Chris, I hadn't picked up on that point about the Omnibus potentially reducing the scope of subject access requests, saying, you know, this is only where you've got concerns about the use of your personal data. Because if we did that, that's basically every subject access request I've worked on in my professional life out the window. Because you know, almost never are they used, or SARs used for the purpose for which they exist in law, which is for people to check accuracy of my personal data, lawfulness of the process. Almost nobody uses a DSAR for that purpose. I mean, of course, it's not difficult to feign some concern about lawfulness of the processing, but yes, that was an interesting one I hadn't picked up on at all. So thanks, Chris.
Well, that's brilliant. I think that's really done a good kind of bit of background for people and hopefully put people's minds at rest as well. Before we wrap up for what I think has been a really good session, I've learnt lots and lots. Hopefully the viewers will as well. Just hot off the press, we now have the updated guidance from the ICO on international transfers. And do you think, guys, that may be something we can have a wee chat next about and share with everybody?
Absolutely. We'll be back soon.
Yeah, I think we should. Yeah, I definitely think we should. There's a lot of new material there. It looks really useful. It looks very user-friendly. There's a glossary. There's a new 3-step test to identify restricted transfers. And there's a different approach to what we used to call transfer risk assessments and are now being called data protection tests. So we're going to get our heads around that and then have a good conversation about it.
That's brilliant. Right. Well, brilliant seeing you all, and everybody out there, watch this space for the next exciting part of the data protection adventure. Cheery bye, Chris, Frank, Liz.
Cheers now. Thanks, everyone.
Bye.